What I really need from my law firm is someone who can provide my staff training so we actually can stay out of trouble.
I really just want somebody who's going to aggressively fight for me in court. Is that too much to ask?
When you have property management problems, we have your solutions. This is the Zona Law Group podcast with the experienced attorneys from Zona Law.
Welcome back to the Zona Law podcast and part 3 of the eviction 3-part series. So this is the finale. It's going to be amazing, guys. I am Mark Zinman. I'm joined here today with Scott Balua.
Happy to be back again, Mark.
And amazingly, you're wearing the same tie as in parts 1 and 2.
Just a coincidence.
It's amazing, isn't it? All right, so part 1 was the pre-eviction. How do you prepare for court? Part 2 was the actual eviction process. Part 3, of course, then is what?
What happens when the case is dismissed, a judgment is entered, and you have a writ of restitution available to get possession of your unit back?
Yeah, so we're talking the post-eviction process right now. Now, as we mentioned in part 2, at court, you're either going to have a case dismissed because the landlord didn't prove their burden, or 2, the judge will enter a judgment. What goes into a judgment once it's entered?
Well, at its essence, a judgment for an eviction case has 2 components to it: a monetary amount that's owed as well as possession. Possession is returned if it's a noncompliance or a non-payment case in 5 days after the entry of judgment, plus whatever court costs, attorney's fees, and other amounts that may be owed pursuant to the lease agreement. So what's a writ of restitution? What does that mean? Well, that means that if they don't voluntarily vacate in the 5 days after the entry of the judgment, on the 6th day, you can contact our office or contact the court and get a writ of restitution. That's the document that authorizes the constable to come out to the property to return possession of the unit to you.
And a writ of restitution, it's put on the judgment itself. The judge will say when the writ of restitution is available. And as Scott mentioned, with most cases, the non-compliance, non-renewal, non-payment, it's a 5-day period before the writ of restitution is available. With an immediate, it's the very next day. It's 12 to 24 hours later. So you get a judgment on Thursday on an immediate. The writ is available on Friday. What is really important here is that the writ is not done automatically. I would say in most cases we don't request the writ. There's a couple reasons for that. One, the tenant may move out, of course, and just turn in the keys. The tenant says, you know what, I don't want to be here anymore anyways. Here's the keys. I moved out. You don't need the writ if possession's been returned by the tenant. But 2, a lot of times, which is what we suggest as well, is the landlord should try and work with the tenants to see if something can be resolved. I always tell clients, the eviction is not necessarily the end of the road. You can work with them after right?
Right, and inevitably, you're going to have tenants that are going to come to you that are going to say, hey, I had this judgment that was entered against me. Is there something that we can do to try to work things out? Yes, you have that possibility, but you do need to make sure that anything that you do is in writing. So, for example, if it's a non-payment of rent case, and they say, well, I have half of the amount that's due. Will you reinstate the lease agreement and allow me to continue to stay? If you agree to do so, you sign an agreement that says, I'm accepting this amount of money. However, you have to make the rest of the payments. And if not, then I can order that writ of restitution to have the constable come out to get possession of the unit back.
Yeah, and it's really common, and honestly, we do suggest it a lot for clients, especially in non-payment of rent cases, to continue to work with your resident. All the judgment did, it awards you possession via the writ, but it effectively solidifies what the amount is owed. So imagine you had a case for non-payment where the tenant just disputes it, maybe saying, oh, I don't know those electric charges, or I don't know that notice fee. The judge is the one deciding, yes, this is the exact amount that's owed. You owe this dollar figure. And once that's decided, then the parties can potentially work to actually get that amount paid, and the landlord has the discretion to do that. Now, that's especially common now because of rental assistance.
Right. There's a lot of programs out there to help assist tenants, and sometimes the process doesn't work as quickly as we would need it to in order to meet the timelines for an eviction, for service of a notice. But after a judgment's entered, if you got an approval letter from a rental assistance agency saying they're going to pay everything, well, why not reinstate unless there's some other issues that are going on? Now, it might become a more complicated issue if there's an immediate or if there's a non-compliance, because let's say that the non-compliance was associated to a roach infestation. That's a situation you may not want to reinstate the lease agreement because it's not the payment of the money that's the issue. It's the behavior that's potentially causing a risk to the rest of the community. And it's the same thing with a criminal act too. There's very limited circumstances in which you may want to reinstate a lease agreement. But if it was for excessive noise, or if it was an unauthorized occupant and you got confirmation that the unauthorized occupant left and you're satisfied with that and you want to reinstate the lease agreement, nothing stops you from accepting payment and allowing the tenant to continue to remain.
And we had mentioned in parts 1 and parts 2, Arizona is a cure state for a lot of the types of notices, especially the non-payment of rent, where the tenant can cure the non-payment of rent up until the point that the judgment is actually signed. After judgment is signed, you no longer have to accept the money. However, you do have the discretion to do so, and that's what we advise clients is if the money's coming, why would you do the eviction? No landlord wants the vacant unit. They don't want the delinquency there and then try and find a new resident, clean it up between residents. I think it was a study done. It was somewhere around like $4,000 for a landlord to turn a unit, go through the eviction process, and then find the new tenant. That's if they find them quickly. There also could be months of vacancy. So if you can keep the tenant there, if rental assistance is coming, that's great. You just need to know your legal rights one way or the other and then try and work with the tenant within the realm of what your rights are. So as we mentioned, you have the availability to get the writ of restitution in most cases, but for an immediate after 5 days. So let's say tenant doesn't pay, tenant doesn't offer anything, landlord has to file the writ on day 6. What does that look like? They contact us, we file the writ. What's the process?
Sure. So after you contact your office or contact the court to request a writ of restitution, that document is presented to the judge, usually the same day or the next day. The judge signs off on it. Judge then has one of their court staff take it over to the constable's office, drop it in their inbox. The constable will then go through whatever stack of writs of restitution that they have available, and then when they get to yours, they'll reach out and give you a call. They'll schedule a time to do the lockout. Now, that could end up being a week or so after the date that you request a writ of restitution. On immediates, where it's a more urgent matter, oftentimes you'll get a call sooner than that, but you'll want to work with the constable, figure out a time that's workable for the landlord as well as the constable, and then schedule to meet at the property on that day. But there's certain circumstances in which that process could be circumvented. Can you tell us about one of those?
Yeah, I mean, a tenant could potentially file an appeal, which would affect things if they're basically asking a higher court to review it. They also have to pay bonds into the court, so it's not just a easy peasy kind of thing. I mean, there's obligations to protect the landlord's interest if that happens. Then they have to continue to pay into the court after that as well. And an appeal isn't just just so everybody knows, appeal, again, that's its own podcast by itself because there's a lot there. It's not just some other court just reviews and has a whole nother trial right then and there. They actually write briefs. We get to respond with our own brief, and an appellate court listens to the transcript and is just deciding whether the lower court made a mistake. So they have to the tenant would have to point out mistakes that the judge had done for an appeal to carry.
And the most important component of that is whether or not the constable is going to come out. As Mark said, if they post the correct amount of money to the court and they continue paying that amount, then they could potentially stay in the property and the constable is not going to come out and you can't request the writ of restitution. But
on a non-payment of rent case. It could be different on immediates or non-compliances as well. So if what happens is, like we mentioned, the constable will call you to schedule a lockout. The constable will go through there, go into the unit, remove the person that's there, and it's your job to then change the locks. At that point, you have legal possession back. At that point, you can turn off the utilities if that's something that you do, or just lock up the unit. What it comes down to is what happens with the tenant's property. If the constable's there, the tenant's there, there's certain stuff that you have to allow the tenant to take, like the basics of their job, documentation that they would need, any kind of medication, kind of the life basics. They're allowed to go in their unit and take that stuff out. However, their couches, maybe their TV, everything else, you have an obligation as the landlord to store that stuff for 14 days.
Right, and you have to send notice out as well to the last known address, and in many circumstances, if a writ of restitution is being served, then it's going to be the address of the unit, and then hold and store that personal property, and then if a certain time period passes and the tenant doesn't come to claim it, then you can dispose of it either by donating it to Goodwill, or if it's trash, then trashing it out. The key here is to good documentation. Again, saves everybody. Take pictures, take videos of the property. So you're essentially creating an inventory of what's there so that if there's any claims later, then you'll have protection saying, well, look, I took a video right at the time that the writ was executed or shortly thereafter. This is what was in there.
Yeah. Again, in the world where you have a camera, a video recorder on your phone, it's very easy to walk through a unit, take pictures, take video to show what's there, to show what the damage is well. And we'll talk about a security deposit accounting here briefly, even though that's also another podcast into itself. We'll talk about it here for a second. But you can very easily show what the condition of the unit is. It should never be a case where you want to go after a tenant for damages and you don't have pictures showing the damages. I mean, it just doesn't make any sense. It's such an easy time to get those things done. So when the constable goes out there, they're going to remove the resident. You'll change the locks. At that point, you've got your possession. You have 14 days. You have to store that stuff. As Scott said, you can donate it. If your lease provides, and if there's no value, you may be able to trash it out. Or you may the other option is going through a sale, which we don't see a lot of clients doing, but that is a possibility as well. So those are the three options. If a tenant comes, though, during the time where you're storing it, what are your remedies? What are your rights?
Well, if a tenant shows up and they want to collect their personal property during that time period, then as the landlord, you have to release it to them. Now, let's say that the property stayed inside the unit and you don't have any moving and storage costs associated with it. Well, then
you still have storage costs. You just don't have moving costs.
Right. So in that circumstance, you wouldn't end up charging anything against the tenant in order to collect their personal property. You just allow them to take their stuff. But let's say that you had a tenant that was going to be moving in immediately after and you needed to clear out the space. So let's say you move the items to a pod or some other storage location. Well, and there's moving and storage costs associated with that. You could charge those amounts against the tenant. However, in most circumstances, you don't want to continue to hold on to personal property even longer than you would otherwise need to. So our recommendation is just to
work with the resident as much as possible is what it comes down to. You have a legal right to charge the storage, to charge the moving. And the storage fee could be as well as if it's in the unit where you're just literally lost somebody else renting it. There's a storage cost to that as well. But obviously the landlords, their intent as much as possible is to turn the unit, re-rent the unit, and get somebody else in there that's paying the rent. I mean, that's ultimately what the business model is. Evictions are not what landlords want to do. So the sooner you can get the tenant to come pick up their stuff, the better. Working with them on the storage fees or doing whatever else you can to just get the stuff out so you can get a paying tenant in there is really an important part.
And one of the questions we often get is like, how accessible do you have to be in order for the person to come and collect their personal property? We've had situations where there's excessive amounts of personal property that's accumulated in the unit and they want to come back for 2 hours here and 2 hours there and over a 2-week period of time. Our recommendation is typically like schedule a time during business hours, one day, bring a truck, get everything in one shot rather than it being broken up into multiple different days.
Yep, exactly. And in certain cases, is that not possible? Yes, I'm sure. If the person's been there 10 years in a single family home that's 4,000 square feet, one day may not cut it. But most of the time, you're going to be able to get it done in one day, and that's a reasonable time period to give. And the statute doesn't actually address what is specifically required. So we come back to that. The default in the law, which of course for anything, is what's reasonable. And we mentioned it as well, your security deposit accounting. Landlords have 14 business days to send out a security deposit accounting from when they get possession back. It's also when the lease terminates and demand from the tenant as well. But really the easiest way just to be safe is to start from the day you get possession, 14 business days, so you don't count weekends, you don't count holidays. Send out an accounting of what you've done with the tenant's deposit, which goes to damages, rent that's owed. This is entirely critical, and there will be another podcast on just that alone, is there's extra penalties for not timely returning a deposit or improperly withholding amounts. So it's critical that landlords know those things.
Yeah, if the security deposit accounting doesn't go out on time, or you took deductions from the security deposit that are not allowable under the law, then that's going to be a problem. Now, if you had a judgment that was entered and you're doing the security deposit accounting, it's probably not going to be an issue because you'll be able to deduct whatever the amount of the judgment, the court costs and the attorney's fees, plus any after accruing costs from the judgment. So it's likely not to be an issue there. But on other tenants where you are sending the security deposit accounting, that's where it's going to become more of an issue, because you need to make sure that you're taking good documentation. Again, just like with everything else that we've been discussing here, good documentation will end up saving the day.
Do you notice a theme with attorneys? We're like, just document. I can't even imagine how many times I've said that to clients. It makes our lives so much easier, whether it's an eviction, fair housing lawsuit, or even a medical malpractice. Everything comes down to the documents. It makes my life easier. It just makes me happy to see good files kept by clients. With the security deposit accounting as well, you just got to make sure it's sent out We have a lot of times where clients are like, well, I don't know all the damage. The tenant gutted the property. How am I supposed to know what it all is within that 14 days? In those cases, again, send out the accounting. You can use estimates if you have from vendors. That's really the rare case. Usually it's more of a monetary issue, like they didn't pay rent. But something has to be in the mail, first-class mail to the resident's last known address within that. I can't hammer that home enough.
Right. And a lot of times there's situations like you're not going to have an exact estimate. Then put an estimate together. And then once the hard costs are known and you know what the repairs were done, then send a revised accounting statement. And if there's money that's due back to the tenant, make sure that you deliver it back.
Yeah. And so this is really part 3. I mean, that is the post-eviction, what your remedies are. We can't stress it enough, though. I mean, obviously, if you can work with the resident, keep them there and have them as a paying resident, and you don't have other non-compliance and other problems, that's great. That's a win-win for you as well as the resident. Once the judgment is paid off, if you are getting money, whether rental assistance or they just came up with the money, make sure you satisfy the judgment as well. That's the landlord's obligation. And in certain cases, the tenant may ask you to vacate it as well, which just wipes it away like as if it never happened.
Yeah, I would second that. It's key to try to work with tenants as much as possible. Again, your goal there is to try to keep that unit occupied and make sure that the landlord is being made whole for any damages that they had. And if the landlord's being made whole, then it's probably a good idea to reinstate the lease agreement.
You guys, it's always a pleasure. Until next time, we'll see you at the Zona Law Podcast.